Welcome to the appendix, where we read the primary sources of the past so the present can be better understood. Today's primary source, the Kentucky and Virginia resolutions of 1798. The Kentucky and Virginia resolutions of 1798 were invoked by the Alien and Sedition Acts. The Kentucky resolutions were drafted by Jefferson and sponsored in the Kentucky legislature by John Breckinridge. The Virginia resolutions were drafted by Madison and introduced by John Taylor of Caroline. These resolutions represent not so much a constitutional as a social philosophy. They were drawn up with the primary purpose not of presenting a constitutional theory, but of presenting a democratic protest against what was considered a dangerous usurpation of power by the central government. The perplexing question of the proper authority to pass on problems of constitutionality had not yet been resolved in favor of the courts, and it was not unreasonable for those who feared the centralizing tendencies of the federal government to assert that the states were the proper parties to decide this question. The resolutions of 1798 drew forth replies from several states. Kentucky Resolutions, November 16, 1798. 1. Resolved that the several states composing the United States of America are not united on the principle of unlimited submission to their general government, but that by compact under the style and title of Constitution for the United States and amendments thereto, they constitute a general government for special purposes, delegated to that government certain defined powers, reserving each state to itself the residuary mass of rights to their own self-government, and that whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force, that to this compact each state acceded as a state, and is an integral party, its co-state forming as to itself the other party, that the government created by this compact was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion, and not the Constitution, the measure of its powers, but that, as in all other cases of compact among parties having no common judge, each party has an equal right to judge for itself, as well of infractions as of the mode and measures of redress. 2. Resolved that the Constitution of the United States, having delegated to Congress a power to punish treason, counterfeiting the securities and current coin of the United States, piracies and felonies committed on the high seas, and offenses against the laws of nations, and no other crimes whatever, and it being true as a general principle, and one of the amendments to the Constitution, having declared that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Therefore also, the Sedition Act of July 14, 1798, as also the act passed by them on the 27th day of June, 1798, entitled An Act to Punish Frauds Committed on the Bank of the United States, and all other of their acts which assume to create, define, or punish crimes other than those enumerated in the Constitution, are altogether void and have no force, and that the power to create, define, and punish such other crimes is reserved and of right appertains solely and exclusively to the respective states, each within its own territory. 3. Resolved that it is true as a general principle, and is also expressly declared by one of the amendments to the Constitution, that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people, and that no power over the freedom of religion, freedom of speech, or freedom of the press, being delegated to the United States by the Constitution, nor prohibited by it to the states, and all lawful powers respecting the same did of right remain, and were reserved to the states or to the people, that thus was manifested their determination to retain to themselves the right of judging how far the licentiousness of speech and of the press may be abridged without lessening their useful freedom, and how far those abuses which cannot be separated from their use should be tolerated rather than the use be destroyed. And thus also they guarded against all abridgment by the United States of the freedom of religious opinion and exercises, and retained to themselves the right of protecting the same as the state, by a law passed on the general demand of its citizens, had already protected them from all human restraint or interference, and that in addition to this general principle and express declaration, another and more special provision has been made by one of the amendments to the Constitution, which expressly declares that Congress shall make no law respecting the establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, thereby guarding in the same sentence and under the same words the freedom of religion, of speech, and of the press, insomuch that whatever violates either throws down the sanctuary which covers the other, and the libels, falsehoods, defamation, equally with heresy and false religion, are withheld from the cognizance of federal tribunals. That therefore the Sedition Act, which does abridge the freedom of the press, is not law, but is altogether void and of no effect. 4. Resolved, that the alien friends are under the jurisdiction and protection of the laws of the states wherein they reside, that no power over them has been delegated to the United States, nor prohibited to the individual states distinct from their power over citizens, and it being true as a general principle, and one of the amendments to the Constitution having also declared that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. The Alien Act of June 22, 1798, which assumes power over alien friends not delegated by the Constitution, is not law, but is altogether void and of no force. 5. Resolved, that in addition to the general principle, as well as the express declaration that powers not delegated are reserved, another and more special provision inserted in the Constitution from abundant caution has declared that the migration or importance of such persons as any of the states now existing shall think proper to admit, shall not be prohibited by the Congress prior to the year 1808, that this Commonwealth does admit the migration of alien friends described as the subject of the said Act concerning aliens, that a provision against prohibiting their migration is a provision against all acts equivalent thereto, or would be nugatory, that to remove them when migrated is equivalent to a prohibition of their migration, and is therefore contrary to the said provision of the Constitution, and void. 6. Resolved, that the imprisonment of a person under the protection of the laws of this Commonwealth on his failure to obey the simple order of the President to depart out of the United States, as is undertaken by the said Act entitled An Act Concerning Aliens, is contrary to the Constitution, one amendment to which has provided that no person shall be deprived of liberty without having process of law, and that another having provided that in all criminal prosecutions the accused shall enjoy the right to a public trial by an impartial jury, to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The same act undertaking to authorize the President to remove a person out of the United States who is under the protection of the law on his own suspicion, without accusation, without jury, without public trial, without confrontation of the witnesses against him, without having witnesses in his favor, without defense, without counsel, is contrary to these provisions also of the Constitution, is therefore not law, but utterly void and of no force. That transferring the power of judging any person who is under the protection of the laws from the courts to the President of the United States, as is undertaken by the same act concerning aliens, is against the article of the Constitution, which provides that the judicial power of the United States shall be vested in courts, the judges of which shall hold their offices during good behavior, and that the said act is void for that reason also, and that it is further to be noted that this transfer of judiciary power is to that magistrate of the general government who already possesses all the executive and a qualified negative in all the legislative powers. 7. Resolved that the construction applied by the general government and is evinced by their sundry of their proceedings to those parts of the Constitution of the United States which delegate to Congress a power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, and to make all laws which shall be necessary and proper for carrying into execution the powers vested by the Constitution in the government of the United States or any department thereof, goes to the destruction of all the limits prescribed to their power by the Constitution. That words meant by that instrument to be subsidiary only to the execution of the limited powers ought not to be so construed as themselves to give unlimited powers, nor a part so to be taken as to destroy the whole residue of the instrument. That the proceedings of the general government under color of these articles will be a fit and necessary subject for reversal and correction at a time of greater tranquillity, while those specified in the proceedings resolutions call for immediate redress. 8. Resolved that the preceding resolutions be transmitted to the senators and representatives in Congress from the Commonwealth, who are hereby enjoined to present the same to their respective houses, and to use their best endeavors to procure, at the next session of Congress, a repeal of the aforesaid unconstitutional and obnoxious acts. 9. Resolved, lastly, that the governor of this Commonwealth be, and is hereby authorized and requested to communicate the preceding resolutions to the legislatures of the several states, to assure them that this Commonwealth considers union for specified national purposes, and particularly for those specified in their late federal compact, to be friendly to the peace, happiness, and propriety of all the states, that faithful to that compact according to the plain intent and meaning in which it was understood and acceded to by the several parties, it is sincerely anxious for its preservation, that it does also believe that to take from the states all the powers of self-government and transfer them to a general and consolidated government without regard to the special delegations and reservations solemnly agreed to in that compact, and transfer them to the general and consolidated government without regard to the special delegations and reservations solely agreed to in that compact, is not for the peace, happiness, or prosperity of the states, and that therefore this Commonwealth is determined, as it doubts not its co-states are, tamely to submit to undelegated and consequently unlimited powers in no man or body of man on earth, that if the acts before specified should stand, these conclusions would flow from them, that the general government may place any act they think proper on the list of crimes and punishments it themselves, whether enumerated or not enumerated by the Constitution, cognizable by them, that they may transfer its cognizance to the President or any other person who may himself be the accuser, counsel, judge, and jury, whose suspicions may be the evidence, his order, the sentence, his officer, the executioner, and his breast the sole record of the transaction, that a very numerous and valuable description of the inhabitants of these states being by this president reduced as outlaws to the absolute dominion of one man, and the barrier of the Constitution thus swept away from us all. No rampart now remains against the passions and the powers of a majority of Congress to protect from a like exportation or other more grievous punishments the minority of the same body, the legislature, judges, governors, and councilors of the states, nor their other peaceable inhabitants who may venture to reclaim the constitutional rights and liberties of the state and people, or who, for other causes, good or bad, may be obnoxious to the views or marked by the suspicions of the president, or be thought dangerous to his or their elections or other interests, public or personal. That the friendless alien has indeed been selected as the safest subject of a first experiment, but the citizen will soon follow, or rather has already followed, for already has a sedition act marked him as its prey. That these successive acts of the same character, unless arrested on the threshold, may tend to drive these states into revolution and blood, and will furnish new calamities against republican governments, and new pretexts for those who wish it to be believed that man cannot be governed but by a rod of iron, that it would be a dangerous delusion were a confidence in the man of our choice to silence our fears for the safety of our rights, that confidence is everywhere the parent of despotism. Free government is founded in jealousy and not in confidence. It is jealousy and not confidence which prescribes limited constitutions to bind down those whom we are obligated to trust with power. That our Constitution has accordingly fixed the limits to which and no further our confidence may go. And let the honest advocate of confidence read the Alien and Sedition Acts, and say if the Constitution has not been wise in fixing limits to the government it created, and whether we should be wise in destroying those limits. Let me say what the government is, if it be not a tyranny, which the man of our choice have conferred on the President, and the President of our choice has assented to and accepted over the friendly strangers to whom the mild spirit of our country and its laws had pledged hospitality and protection, that the men of our choice have more respected the bare suspicions of the President than the solid rights of innocence, the claims of justification, the sacred force of truth, and the forms of substance of law and justice. In questions of power, then let no more be heard of confidence in man, but bind him down from mischief by the claims of the Constitution. That this Commonwealth does therefore call on its co-states for an expression of their sentiments on the acts concerning aliens and for the punishment of certain crimes herein before specified, plainly declaring whether these acts are or not authorized by the federal compact, and it doubts not that their sense will be so announced as to prove their attachment unaltered to limited government, whether general or particular, and that the rights and liberties of their co-states will be exposed to no dangers by remaining embarked on a common bottom with their own, that they will concur with the Commonwealth in considering the said acts so palpably against the Constitution as to amount to an undistinguished declaration, that the compact is not meant to be the measure of the powers of the general government, but that it will proceed in the exercise over these states of all powers whatsoever, that they will view this as seizing the rights of the states and consolidating them in the hands of the general government, with a power assumed to bind the states, not merely in cases made federal, but in all cases whatsoever, by laws made, not with their consent, but by others against their consent. that this would be to surrender the form of government we have chosen, and to live under one deriving its powers from its own will, and not from our authority, and that the co-states recurring to their natural right in cases not made federal will concur in declaring these acts void and of no force, and will unite with this Commonwealth in requesting their repeal at the next session of Congress. Virginia Resolutions, December 24, 1798. Resolved that the General Assembly of Virginia doth unequivocally express a firm resolution to maintain and defend the Constitution of the United States and the Constitution of this state against every aggression, either foreign or domestic, and that they will support the government of the United States in all measures warranted by the former. That this assembly most solemnly declares a warm attachment to the Union of the States, to maintain which it pledges all its powers, and that, for this end, it is their duty to watch over and oppose every infraction of those principles which constitute the only basis of that Union, because a faithful observance of them can alone secure its existence and the public happiness. That this assembly doth explicitly and peremptorily declare that it views the powers of the federal government as resulting from the compact to which the states are parties, as limited by the plain sense and intention of the instrument constituting that compact, as no further valid than they are authorized by the grants enumerated in that compact, and that in case of a deliberate, palatable, and dangerous exercise of other powers not granted by the said compact, the states who are parties thereto have the right and are in duty bound to interpose for arresting the progress of the evil, and for maintaining within their respective limits the authorities, rights, and liberties appertaining to them. That the General Assembly doth also express its deep regret that a spirit has in sundry instances been manifested by the federal government to enlarge its powers by forced constructions of the Constitution Charter which defines them, and that indications have appeared of a design to expound certain general phrases which have been copied from the very limited grants of powers in the former Articles of Confederation, were the less liable to be misconstrued, so as to destroy the meaning and effect of the particular enumeration which necessarily explains and limits the general phrases, and so as to consolidate the states by degrees into one sovereignty, the obvious tendency and inevitable consequence of which would be to transform the present republican system of the United States into an absolute or, at best, a mixed monarchy. That the General Assembly doth particularly protest against the palpable and alarming infractions of the constitutions in the two late cases of the Alien and Sedition Acts passed at the last session of Congress, the first of which exercises a power nowhere delegated to the federal government, and which by uniting legislative and judicial powers to those of the executive subverts the general principle of free government as well as the particular organization and positive provisions of the federal Constitution, and the other of which acts exercises in the like manner a power not delegated by the Constitution, but on the contrary expressly and positively forbidden by one of the amendments thereto, a power which, more than any other, ought to produce universal alarm, because it is leveled against the right of freely examining public characters and measures, and of free communication among the people thereon, which has ever been justly deemed the only effectual guardian of every other right. That this state having, by its convention, which ratified the federal Constitution, expressly declared that, among other essential rights, the liberty of conscience and of the press cannot be cancelled, abridged, restrained, or modified by any authority of the United States, and from its extreme anxiety to guard these rights from every possible attack of sophistry or ambition, having with other states recommended an amendment for that purpose, which amendment was in due time annexed to the Constitution, it would mark a reproachful inconsistency and criminal degeneracy if an indifference were now shown to the palpable violation of one of the rights thus declared and secured, and to the establishment of the precedent which may be fatal to the other. That the good people of this Commonwealth, having ever felt and continue to feel the most sincere affection for their brethren of the other states, the truest anxiety for establishing and perpetuating the union of all, and the most scrupulous fidelity to that Constitution which is the pledge of mutual friendship and the instrument of mutual happiness, the General Assembly doth solemnly appeal to the like dispositions of the other states, in confidence that they will concur with this Commonwealth in declaring, as it does hereby declare, that the acts aforesaid are unconstitutional, and that the necessary and proper measures will be taken by each for cooperating with this state in maintaining unimpaired the authorities, rights, and liberties reserved to the states respectively or to the people. Thank you for joining us for our primary source today on the appendix. We will see you in the stacks.